Good morning and welcome to another edition of Coffee Talk with Austin Ondenman, attorney at law. Today we're going to be talking about the overlap of federal immigration law with state, in this case Commonwealth, criminal law, uh, specifically with a concentration on the Commonwealth of Massachusetts. So the first thing you have to determine when you have been charged with a crime and are an immigrant is what kind of immigrant you are. And what I mean by that is, are you currently present lawfully or are you present unlawfully? How do you know if you're present unlawfully? Well, if you went through the border and didn't get checked by customs or by immigration, if you didn't come in with a visa and you had what they call pop the border, then you are present unlawfully and are already removable. If you came over on a visa and you overstayed your visa, like a tourist visa, and you didn't go back when you were supposed to, you're currently presently unlawfully and are removable. This is important when we talk about the concept, the realm of detention, because I did another segment on how you can become detained in a criminal case. If you are detained, it's very easy for Immigration Customs Enforcement to issue an detainer, an ICE detainer against you, and take you into custody for immigration purposes and proceed with removal proceedings. There's a great decision that came down from the Supreme Judicial Court. This decision basically stated that for individuals who have been held by a state court, whether they've just been arrested, well, specifically the court, when a court has arrested somebody and has them in custody at that time, there's no requirement for the court to hold the person and wait for immigration to get there when an ICE detainer has been issued. It's up to immigration to come and get the person when the person's there. So you have this absurd situation where a person's been arrested, charged with a crime, they get arraigned, they get released on personal recognizance, and as when they walk outside the courthouse, immigration comes and picks them up and takes them away. If you are a green card holder, that doesn't mean you're out of the that you're off the hook. If you have a green card, you're still subject to removability. You can be removed based upon certain criminal convictions. So they have to have you convicted before they can remove you. Otherwise, you're present lawfully and you have lawful immigration status. If you're here on a non-immigrant visa, like a tourist visa, student visa, you could find yourself in a situation where that visa is revoked because the conduct that you're accused of is of such a nature that in their discretion they revoke the visa. Because you're not in an immigration status, you have no right to remain. It's always subject to the discretion of immigration, and they can remove it and ask for you to leave at that point. Returning to the issue of criminal charges and immigration, regardless, you got to think about your criminal defense in a different way. There are remedies for citizens that can be utilized by citizens that have very severe consequences for green card holders or any other immigrant for that matter. There's a resolution, a disposition called continuation without finding. Continuation without finding is a wonderful thing for individuals citizens who have been charged, because they get up, they admit to the sufficient facts against them, and they get put on a period of probation, and once that period of probation is done, the case is dismissed, and most background checks won't pick it up. I say most because there are more intensive background checks that certain companies and certain government agencies will do, and it will come up at that point. However, when it comes to an individual who has been charged with a crime that is a green card holder, sufficient facts, which is the admission, you admit to sufficient facts, when coupled with any type of deprivation of liberty, which doesn't mean being arrested or being incarcerated. It could also mean being on a period of probation, having conditions of probation. Any period of probation is a deprivation of liberty by case law. When those two things are coupled together, that is a conviction for purposes of immigration law. And when you have a conviction for purposes of immigration law, then it's just a question of what type of crime we're talking about. So now let's get into the crimes that can make you removable. One is an aggravated felony, and this is of course something that you should always consult with an attorney about. Defense attorneys are expected to understand this interplay, but it is a new responsibility, relatively new responsibility for defense attorneys, and it is a little convoluted, so defense attorneys sometimes have to put some time in to figure out how these two interplay. Essentially, I bring that up because this is not something that you should rely upon. This is something that you should discuss and work with counsel to determine. But the aggravated felony is certain types of crimes defined by the context, that when committed and when a conviction is attained, can make a person removable if they have a sentence of a year or more. There's also there's also other crimes that just by their nature, doesn't even matter how long they're incarcerated for, but by their nature are crimes that reach some type of definition, and they make you removable as soon as there's a factual finding and a deprivation of liberty. So when those offenses are charged, you have to be very aware of them because they are in themselves an individual basis for removability. The third one is a crime involving moral turpitude, which is a loose defense. For instance, most operating under the influence charges won't be, when their first initial charges, crimes involving moral turpitude, but if there's certain specific facts in the record that indicate that there's some type of that reflect negatively on a person's character, it can very quickly shift from a simple crime to an offense involving moral turpitude. There is the definition of the penalty scheme for that is any crime where there's a potential penalty of a year or more. Now, a lot of the crimes are written with minimums, sometimes mandatory minimums, to maximum penalties. When a maximum penalty is a year or more, and that's in a lot of cases, a lot of charges, then the person can be put in a position where they find themselves pleading out to a case that is a crime involving moral turpitude and makes them removable. And again, a quaff will make a person removable. Nice example of this distinction is the larceny over $250 charge in Massachusetts and shoplifting under $100. If you've been charged with larceny over $250 because you're alleged to have stolen a bunch of stuff, that's a crime involving moral turpitude because it's theft, and because the potential penalty is up to 2.5 years in the district court, you are removable as soon as you plead to that. It's a felony because it can also be charged in the Superior Court, and you can do state time. So it's a felony, and it's also a crime involving moral turpitude that has a potential penalty of up to 2.5 years in the district court. Shoplifting, however, for a first offense is what they call a petty offense exception. It does not have a potential penalty of a year or more. So one of the creative things you can do, if it looks like the case is not going the defendant's way and they're likely to get convicted, and for one reason or the other, the prosecution is looking to get some type of criminal penalty, is you can ask for it to be stepped down to shoplifting and plead the person out for shoplifting instead of larceny over $250. But there's a lot of important things that need to be done at the plea, because you have to make sure that the record doesn't reflect an amount. The record read into the record when they read the facts. You got to talk with the Commonwealth about that. Does not mention the amount of money, because if there's sufficient facts for larceny over $250, even though there's a lesser charge that was pled to, the sufficient facts can be used to boost that up to an actual crime involving moral turpitude. There's something called pretrial probation. This is such a great tool for immigrants who are first time they're being charged with a crime that is potentially removable. Issue one, you got to get the Commonwealth to agree. You can't do it over their objection most of the time. I have seen it done over the Commonwealth's objection. Technically, it's not constitutional. Everyone knows that, but it has been done. I'm not going to say where, but it can't be done over the Commonwealth's objection. according to the Constitution of the Massachusetts Declaration of Rights and constitutional principle of separation of powers. So you need to get the Commonwealth on board. And you do this by creating a whole little plea packet with exhibits and with attachments. And basically, you're trying to point out to the Commonwealth, this is not a bad guy. He made a mistake, or her, or she, but they made a mistake. This person made a mistake, and they're trying to, address it. They're willing to pay back restitution, or there's no need for restitution. All the items were returned when they were caught, or the person, whatever the crime is, they're willing to atone in a way that may try to make the alleged victim whole. They got all these great contacts with the community. They know that they go to church. They have this contact with the church. Here's a letter from the pastor. Here's a letter from their spouse. Here's a letter from friends and family that know them. Here's a letter from their employer. They work. They are, they're trying to raise their child in the United States. And then you bring up the fact that if they get this conviction, they're going to be deported. And that's a very harsh consequence for an immigrant who basically just picked up some stupid charge. And it's an unintended consequence as from the state's perspective, and they are allowed, and there's case law that supports this, to take into consideration the what they call the ancillary concerns, collateral consequences. Took me a moment. Take into the consideration these collateral consequences that can affect a person's differently than what's maybe the statute intends. For instance, some charges, collateral consequences. You can lose your commercial driver's license, and that maybe might not be what the prosecution wants to do based upon that case. So you ask them to take into consideration those consequences, those collateral consequences, and if they say yes, they know they don't have to go to trial. They put the person on a pretrial probation. There's no need for him to admit. If he picks up another offense, the case goes right back to trial. It takes the case off the trial path and puts it on puts it off to the side. When you complete probation, case is dismissed. And if there's restitution to be paid, you pay the restitution. If there's some class they want you go to the class. But you complete the conditions that are attached, including stay out of trouble, and then the case is done. And the person has no immigration consequences from that charge. It's not a conviction under immigration law. So it's a very nice tool, and it's something that you got to work out with the other side. You want to have a defense attorney who has a working relationship with the prosecutors. Sometimes in court, you'll notice prosecutors and defense attorneys being friendly and talking in amicably. It's not so much like the civil bar. We don't necessarily, there is a collaborative spirit sometimes when a case can get resolved, and we're just trying to find a way to meet in the middle, and that's a good thing. It's a good thing if we can get the Commonwealth to agree to something that is fair. If not, they still got to prove their case. And none of what I'm saying right now doesn't take away the fact that the Commonwealth has to prove it beyond a reasonable doubt, and they still have to take it to trial, and they still got to prove it in front of a jury. But keep in mind, any detention can make a person who's already removable likely removed or detained, especially in this current political climate. So, moral of the story is, if you're an immigrant in any shape or form and you're charged with a crime, get some consultation with an attorney immediately. Don't wait. Don't even wait till your arraignment. I mean, I've had clients who called me on the night that they were arrested. I've talked with family members. We've figured out what was going on, and I went in on an emergency basis the next day to their arraignment. And so this is something that can be done, and it's something that you should consider. Again, my number 857-615-2173. If you have any questions involving anything I discussed today, or anything in the general nature regarding criminal, family law, or immigration law, give me a call. 857-615-2173. Have a great day.